Well, thanks everyone. We might get started. I've been informed we're good to go. So the webinar's functioning, and we are obviously taping this session as well for promotion on our website. So you'll be able to go back and revisit some of the presentations today and some of the question and answers. Before we get started, I'd really like to thank the Law Society for the use of their resources and their function centre, and a particular call out to the Property Committee of the Law Society and Christy for coordinating this event. We've got 4 face-to-face events. They're all fully booked. They're all being webinared, and we're videotaping it as well. So we've got very good patronage and coverage at the sessions we're holding over the next 2 weeks. As an overview, there will be some brief presentations that I believe will probably go for an hour and a half. But I see the real value in getting the participants here today to take questions from the floor, to ease any uncertainty, to give further clarification or information where it's required. So we've set aside an hour for a Q&A session, if you like, with all panel members participating. So it's really 2 parts: brief presentations by the presenters, and then over to you to ask any questions which you see fit to ask. So the structure today is really you hear from me. Some of you may be quite sick of that over the 10-year duration for which we've been standing in front of you. But I'm pleased to say we are ever so close with the bill passing the lower house and moving to the upper house, listed to the debate on the 17th of May. With our technical readiness all but green, it's nearly all systems go for the end of May, early June. So you'll hear from me. You will then hear from Tom from RevenueSA. Thank you, Tom. From PEXA, we have Josh, and then probably 2 other gents that don't need any introduction. We have Jeffrey and Phil. And then we'll have a Q&A session at the end, which I see as being a great deal of value. People would have seen this diagram for some time now that we've been talking about this over a few years, and we've been taking positive steps. The first reform that was rolled out was VOI. It was an interesting process, but I think, in my view, things have settled down, and it's become common practice for people to do this process as part of their business and engaging with their clients. The second building block was client authorisation, which is the subject of the bill currently going through Parliament, and it's to be introduced in May in accordance with Electronic Conveyancing. The third reform is priority notices, again introduced 12 months ago. People would have heard me talk about priority notices. It's fair to say use of priority notices as a tool for practitioners is still very much underutilised. Activity levels are low to medium. I will labour on this a bit because people would have heard me before on the use of priority notices, especially linked to the safeguards we need to put in place around the removal of the dupe title. If I look at a practical scenario, remembering these reforms are not just applicable to electronic conveyancing. These reforms are available or need to be complied with for every facet of your business, irrespective of whether you choose to use PEXA or whether you choose to still meet in the settlements room at 101 and go downstairs. And if I take you through a practical example in a world where the dupe title no longer has any relevance, in the new world, in paper, you will rock up to the settlements room. You'll have a transfer that'll be signed by Brenton Pike, legal practitioner, Phil Page, legal practitioner. Signed by 2 people with certifications that they have a client authorisation. I go up to an incoming mortgagee. Here's my transfer. Can you now give me the proceeds that I need to hand on to the vendor? There's no other evidence. There's a paper transfer signed by 2 people. The banks are going to hand over $500,000 or more on this basis. This is where I see the critical role of priority notices coming to the fore. Priority notices can be lodged, and I'd say they need to be lodged now in preparation for the change of law, but they can be lodged 60 days out from settlement. The bank can then search the title for which you're about to settle on. They can get clear disclosure of the series of documents that are being presented by the priority notice. They have that search with them. You present in front of them. They have comfort that their interest is protected by the functioning of the priority notice. It is absolutely important in my view, and it is prudent practice, that priority notices become a common tool of use today. The bill will pass hopefully in the next 2 to 4 weeks. You've got 60 days for the use of a priority notice. Once that bill passes and the act is commenced, dupe titles have no relevance. There's no transition. I'll talk about transition, but there is no transition for dupe titles. Commencement of the act, title's gone. No legal consequence at all. And so these are the main building blocks that we've been working on for the last 2 years with our incremental approach through VOI, priority notices, and now the use of authorizations and the removal of the dupe titles. Unilateral to everything you do. I will take a point in electronic conveyancing. Please be aware that there are a national set of rules that you also must turn your mind to. The model participation rules, they're published on the Land Services website or the sa.gov.au/land services. We'll provide them out as a link through our notice to lodging parties, and also the model participation rules. Please turn your mind to those as statutory instruments that you must also be aware of when you're transacting in the new world. But if I can leave you with one of many things, I strongly advocate, please turn your mind to the use and the proactive use of priority notices as a valuable tool in the absence of a dupe title. There, I've sort of covered it, but as from the commencement of the Act, no effect. Dupe titles, gone, fail to recognise them, they have no relevance. If during the period after it's enacted that they have no effect, you lodge a dealing with the dupe title, I'll destroy it. And obviously you will not be getting one back other than a confirmation. One of the other things to be aware of is the dupe title's sort of been a baton, if you like, in regards to consents to further registration. Mortgagee has a dupe title, someone wants to establish another registration, they seek production of the duplicate title from the mortgagee as a classic example. With no duplicate titles, the Act has been changed where there's no longer a need for that to happen. There's no longer a need for consents. Any subsequent registration at law will be bound by previous registrations. So the Act works in effect that your first registered mortgage, that integrity is preserved by registration. What we need to be careful of is if there are caveats, and they're permissive caveats, and you settle on the face of a permissive caveat, you effectively could be providing registration and the client could be taking on, if you like, that capital interest. It's something to be aware of. Encumbrance panels are being removed from all of our dealings, and our panel forms are being updated in accordance with that direction. So every registration is taken subject to any previous instruments that are registered in the registered book, It is a significant change. We have an encumbrance panel currently. We will no longer have encumbrance panels in our paper documents. Again, national consistency. Again, in PEXA, there is no ability to put in an encumbrance or what we know as an encumbrance panel or a subject to. So you take it, whatever you register is taken subject to existing registrations. People that read Hansard would have seen when the bill went through, the previous bill went through that became an Act that introduced priority notices. There was some commentary around the removal of dupe titles then, and the attorney was on Hansard to say he'll work with the registrar to introduce a product known as Title Watch. So what we have done is we have moved to develop that product. It's an online subscription service that monitors activity against certificates of title. So when an activity is detected, you will be automatically, if you subscribe, of course, to that particular title, you will automatically receive an email and an SMS notifying you that an action has taken place against the register book. There are 4 primary triggers. Someone's ordered a property interest report against a particular title. There's been a priority notice lodged. There's been a dealing lodged, or the title itself is cancelled. In preparation for the bill to go through, the implementation of Title Watch is currently scheduled for May 7. So I sent a notice lodging parties out last week, I think, that gave you some information about an incremental approach to changes that we need to make. The implementation of Title Watch is one of those changes. So you will be able to subscribe to that alert, all being well, which we'll confirm later this week on Monday, May the, whatever date the Monday is. It'll be there. You'll see it in your user, in your menu. As I mentioned previously, client authorizations will be introduced for both paper and electronic dealings. People that remember the various information sessions we've had, it was about keeping it simple and aligning our processes and procedures, and this is the reason for the use of client authorizations in paper, and obviously it flows through to PEXA. There'll be a offence if you execute on behalf and you don't have the authority to do so. There'll be some optional use of them for caveats and priority notices, given the urgency that could play out in regards to those particular dealings. And there's a couple of exemptions around client authorizations. 2 of them, the documents listed there, require declarations or personal declarations, so therefore it wouldn't be appropriate for client authorizations. And the others can be categorised as division type docs, your RTCs, your ACTs, etc. So the client authorizations in regards to those docs can't be utilised. They still need to be executed by, if we use the word applicant, they still need to be executed by the applicant. But for every other dealing in paper or through PEXA, if we categorise them as straight dealings, you will get authorisation to sign on behalf of your client, whether they're the transferor or transferee. That authorisation is now published. It's available on the ARNIC website. I believe there's a link on the landsa.gov.au website to that authorisation, so you can start familiarising yourself with it. A word of caution though, I would be reluctant to probably sign up too many of your clients at this stage, given it doesn't have any legal effect. It's contained in the Act. So once the Act passes, the effect will become legal. So look, familiarise yourself, have the conversations with your clients, by all means, and start getting prepared to the impact they'll have on your organisation and the process flow within your office. But you may want to hold off getting them actually signed until they have some legal consequence, because we can't second guess what might happen through Parliament. Certifications, people that have been around for a long time probably sit, when we talk about certified correct for the purposes of the Real Property Act, I'm sure there's 110 people in here. I'm sure if I asked 110 people what that actually meant, I reckon I'd get probably 100 different answers. So what we've tried to do in this bill, or through this, is to codify explicitly what you are certifying when you present a document through registration. It's clearly outlined in the Act under Section 273 if anyone wants to refer to it, but effectively there's 4 pillars that you will be giving certification around. They'll be that you've done your VOI, you've retained the evidence that you need to, that underpins your ability to transact, you'll have client authorisation, and that it's compliant and correct. Practitioners will need to sign, obviously, in electronic. It'll be through the use of a digital signature. In paper, it'll be applying their wet signature. We are in the process of updating all of our panel forms. As you can imagine, with certification changing, the statement on the back needs to be extended. With only you signing on behalf of your client, the execution and acceptance of a transfer is no longer relevant. The witnessing provisions are no longer irrelevant. So the forms are very much being revamped. We're starting on on the high usage forms, so your discharge, transfer, mortgage, withdrawal, caveat and caveat, and they're the 5 that are going to be available through PEXA, and I'm hopeful we'll have those published in the next couple of weeks. And then we'll take an incremental step to the other forms that need to be updated, but they will all be updated within the next 4 to 5 weeks. But we're doing the big bang ones first. So once they are updated and they're published, obviously we'll send out notifications alerting people to the new forms being available. We're obviously working with the AIC for integration into any software that it may need to be integrated into. So the information will be available, but it is going to be very, very prescriptive about what you need to give a certificate for. I have the power to exclude classes or prescribe classes, to exempt them, if you like, from the need to provide certifications. And I'm currently, and the reason I raise that is when we try to apply the broad band of 273 to division documents, i.e. RTCs. RTCs contain a number, or have potential to contain a number of transactions. I'm not sure those certifications need to apply to every transaction within an RTC, for instance. So they might apply to the practitioner who's acting on behalf of the applicant, but the other transacting parties that fulfil part of the RTC, there may need to be an exemption. But I'm currently considering the detail of that, and obviously that'll be the subject to notice lodging parties once I land on a position on that. But it will be a position that will try to reflect the efficiency that it needs to in regards to those particular documents. Mortgage certifications, we have moved in South Australia to mirror, if you like, for a paper mortgage, we have moved to mirror the certifications that can be provided in PEXA. So in PEXA, the mortgagee, if you like, can give a certification that they hold a mortgage, a paper mortgage, granted on the same terms, and therefore the data that goes through PEXA is certified correct by the mortgagee or a representative of the mortgagee, and they give that certificate to the registrar. I've taken that one step and said in paper, you can either lodge with me the same certificate, so the mortgagee can lodge a mortgage with me signed only by the mortgagee that gives me a certificate they hold a mortgage granted on the same terms, or they can still lodge the wet signed mortgage or mortgage executed by the mortgagor. So they have either or. So I've tried again with the alignment principles. I've tried to take away the variation that may exist, if it's PEXA or if it's not PEXA, just to say, look, irrespective of what path you go down, you determine the most effective and efficient manner for which you wish to settle and the conversation you have with your client, and you determine it. But I don't believe there should be any policy or legislative inhibitors in the way to allow you to make that informed judgment. The carrot along that is if the mortgagee oversteps the mark, it's found that there is fraud, highly unlikely. We haven't had too many cases at all, thankfully. I have the power to cancel the mortgage. VOI, as I said, I think it's matured to a point that there is general acceptance of the need to do it as common practice. There'll be some new requirements that come into force with version 3 that will align with the updated legislation. And the reason for that is the VOI at the moment only apply to a very limited set of transactions. Because we've gone down the path to align it, broaden the certifications to all transactions, the VOI needs to be recast in view of that. So effectively there's some changes to it, but effectively the VOI extends itself to all transactions. Again, they'll be published with 20 days notice to allow people to familiarise themselves before they become effective. But I'm hopeful it aligns with the introduction of the new act, or the act that introduces the reforms. One of the other pillars of this is the need for you to determine your client's authority. So anyone that's familiar with the right to deal with the MPR will know the term right to deal. So there's two parts. There's VOI, so you identify who your client is. Then you need to attach your client to the land that you're actually transacting. There could be numerous Brenton Pikes, but it may not be the Brenton Pike that owns the property at Greenwith. It's called Right to Deal through the model participation rules. What we've done here is I've published guidelines around authority. So the authority you need to determine the authority for your client to enter into a transaction. And it's closely linked, well, it's more than closely linked. It's a part of the client authorization. When you enter into a client authorization on behalf of your client, you need to ensure that that person is who they say they are and that they have got the authority to give you the power to act for them in regards to that parcel of land or if that CT or that house. I'm publishing guidelines. Again, they will be published. Anyone that's familiar with the national movement will know there's Right to Deal guidance notes published on the ARNIC website. This authority document or authority guidelines mirror that document. Again, it'll be published with 20 days notice, and it gives you guidelines around what you should do as, in my view, prudent practice, being nationally consistent about how you might determine your client's authority. Likewise, mortgagees are required to verify the authority of the mortgagor. And as I mentioned, there'll be guidelines that will be published that will assist you in determining what may be seen as reasonable steps. Supporting documents need to be retained for 7 years. Again, nationally consistent. We haven't varied too far from that. Some of the documents that you may, well, I'd say you probably do need to keep are obviously your valid client authorization, your evidence around VOI and verification of authority. And if you are lodging caveats or priority notices or anything like that, any instructions you may have. They're just some examples that you may wish to keep and retain as evidence. Some of the broader changes within the Act, caveats, where I've moved a clause that will allow the registered proprietor to the ability to caveat their own property. Previously, we've haven't really allowed that, so we've moved that provision. I can lodge a caveat when it's in the public interest to do so. That's more along the lines of a Registrar General's caveat, extends that power. And I can also prescribe, and again, these will be in regulations, instruments that can be registered and or recorded in the face of a caveat. So people can have some certainty that if they're trying to register a statutory agreement or some other type of instrument to that ilk, that it can be registered notwithstanding a caveat, unless that caveat prescribes its inability to be registered. There's a number of new offences using digital signatures as we move into the new world, or fraudulently using them, client authorizations, etc. And we tried to, where we possibly could, to make the Act technologically neutral. So whether it applies to paper or the new world in PEXA, it'll achieve its goals. It was a fairly difficult task. Transitional provisions. So we've got an Act that's going to commence, let's say June, 1st of June. It's going to change the way everything you do and how you interact with your clients, how you sign documents, and potentially how you settle with the abolishment of the dupe title. I've said before that I will have got the power in the bill, and I will prescribe regulation that will give you 4 months grace period. Again, this will have to be the subject of a extremely detailed notice to lodging parties. I've convened, if you like, a small working group looking at what needs to be covered off around in consideration of these transitional provisions, and it's extensive once you really get into the detail. I will endeavour to cover it all off. We're looking at matrix at the moment to cover off all the various scenarios that may or may not exist. But I would encourage you, I think it's worth reflecting during this 4 months, don't underestimate the complexity and the challenge we'll all face, including me and my staff internally, when we get all the different variations and permutations that can be lodged while we're dealing with the old and the new. My intention is to give regulations that effectively say if you comply with the old law, it's registrable within 4 months. If you're complying with the new law, it's registrable. So I'm trying to give you confidence that notwithstanding all your work in progress should be able to move through in a seamless sense. 4 months from the date the Act commences. I've got the power to extend that should I need to. I will say though, we need to be very careful. 4 months is not very long. The 4 months is tailored towards dealing with work in progress. It's not tailored towards delaying implementation of all the reforms that are necessary. So if we look at a situation about a hybrid transfer, the new world's come in, you can still lodge the transfer signed by a conveyancer or a legal practitioner, generally the representative of the transferee. That can still be executed and accepted by the punter. Where you have one practitioner though that wants to move into the new world, I need to strongly consider how we deal with that, because you'll have a set of certifications that will be in the new world, and you potentially have the transferor's representative or the transferor executing the transfer and witnessing it. So watch this space. If you see any material come out from me, I'm sure there's some material I send out that sort of goes to the inbox, and we might get to it at some point in the future. I would applaud you for the next month, if not 6 weeks, 2 months, to just consciously look at all the material that's disseminated, because there's going to be a lot of detail coming your way, particularly in regards to these transitional provisions. We need to deal with execution, we need to deal with certification, and all the documents that are touched by those. And I need to give you strong guidance on what it will be and what it will look like and what my expectations are to assume to still remain efficient in the settlement process through those 4 months. But I don't want to underestimate the challenge that will take. Some of the things that we've considered, as I said, I've got a small working party. We are looking at the execution and the certifications and what they may or may not look like during that 4 months. But again, it's dealing with work in progress, not necessarily new work. New work, I would say, needs to be catered for under the new regime. The things we're looking about is with the dupe titles going, if anyone's lodged an application for substitute CT. Again, we'll remind you that it's probably, as we get closer, it's probably not worth lodging it. You may be in a position to postpone settlement. If you're not, well, then you lodge it and you let me know, and we'll process them straight through. If there's something critical that needs to be issued on the back of a substitute CT, please let us know. We'll have them processed. Likewise, if there's SC sitting in our office that are unprocessed upon the change of law, I'll be writing to you, say, give me a letter and we'll process a full refund. We'll give you a full refund for those sort of things. Again, we'll do sweep of outstanding corrections. We have a number of summonses that are currently in train, where I've written out summonsing the production of the dupe title. There's about 4. My regs will deal with that work in progress. And effectively we'll cancel those summonses, and obviously there'll be procedural fairness where we'll write out and there'll be a process, but those summonses obviously no longer effective given their dupe title has no relevance. And as I mentioned, executions and certifications is the big one, particularly where you're moving towards a world of dual certifications if we look at the transfer, for instance. Just some screenshots of screens that will change early. I think this changes in May the 7th. As I said, we'll confirm it. Anyone that's lodged priority notices, which I can honestly say there's a couple of conveyancers that lodge them all the time, but they are few and far between. They'll notice there's some changes to the screens within priority notices. Some people may look at this and say, oh, why are we doing this? This is purely because we are creating a national priority notice. Every jurisdiction is moving towards this national priority notice. I asked Steve to take to the Registrar's Working Group our view on whether or not we should do this in a national sense, i.e. disclose the applicant, so who's your client if you're putting on the priority notice, and also the need for, if you like, the 2 rubbery, I use the word rubbery, certifications. Unfortunately, we weren't successful in that dialogue with our interstate colleagues. And because we're committed to the national consistency and the national priority notice, these changes are coming into play on May the 7th. So what it means is you'll have to outline your client as the applicant if you're putting on the priority notice, and you'll have to select a couple of tick boxes that say you've got evidence that supports the priority notice and you've reasonable steps to ensure that it's correct. Doesn't include any fancy digital signatures, doesn't include anything else. It just comes in as and uses your account as recognition of you as a practitioner who can lodge them. Link to the removal of the Duke titles. Obviously, we have title alert, which I've talked about. And again, there'll be a lot of material that will come out about that in the coming days. We're also introducing confirmation of registrations in the latest notice lodging party. I put a link in there for people to have a look at. I hope you took the time to have a look. Effectively, it will be delivered to the lodging and correcting party where they differ. If they're the same, there'll only be one notice. The first page is a summary, and then there's sample pages after that. So this will change the way people would have seen. We've always had confirmation of registrations for dealings that don't require currently the dupe title, transfer of leases, transfer of mortgages. This change will go in again on May the 7th. Those rules will still apply. So if you've got a transfer of lease or transfer of mortgage that's in the process of being registered, you will see a new confirmation of registration, hopefully from next week. Broadly, it'll apply once dupe titles are removed, and obviously every transaction's lodged without a duplicate title. This will be provided back to lodging and correcting parties where they differ, or in PEXA, it'll be back to the responsible subscriber. Again, the latest notice lodging parties included a hyperlink. So the purpose of today really was to give an overview from my perspective, to give you comfort that there'll be an avalanche of information coming out, particularly around the transition requirements and regulations, around how we can try to move that through as seamlessly and efficiently as we can, but also to let you know that there is a whole raft of other training being undertaken. People would be aware the AIC and the Law Society are proposing to conduct training on the new requirements and the new conveyancing requirements. PEXA will be providing training through the AIC, I believe, in around May, if I'm not stealing anyone's thunder. And obviously, I will continue to publish additional information and give you as much comfort as I possibly can as we move through this time of great reform. It is the most significant reform in 150 years, and we can't underestimate the impact it's going to have on all of us as we move through this reform. As I mentioned, the new forms will be available mid-May. If anyone has any questions, comments, obviously we'll have a Q&A session after the presenters have presented. I'm happy to receive any emails, any information you want, anything you think would add value by way of communication or publication. Please let me know. Don't sit on your hands. If you think it's something that's missing or there's a gap, please bring it to someone's attention in the LTO. Happy for it to come directly to me, Steve or Christy, and we'll try to publish something that gives the direction that I'm responsible for as we move through this reform. So that's all I was going to give an overview of. As I say, I'll be part of the panel. I'm happy to hear all the questions or points of clarification that are required. But next on this information sharing is Tom. Thanks, Tom.
Thanks for that. Thanks for that, Brenton. Good afternoon, everyone, and welcome to RevenueSA section of the presentation. My name's Tom Colmer. I've been responsible for managing the e-conveyancing project within RevenueSA. Most of my stuff will be a lot less legislative and a lot more system-based, and also discussing how we see the process working. We're now looking at interactions between the PEXA system and the RevNet system. So as a result of that, we've had to make some system changes, and I also wanted to touch on the interfaces and how that will actually impact users. So as you do now, you'll be required, if using PEXA, to self-determine all your documents in RevNet, and you have to get a RevNet ID at some point, and that's what you'll be using in PEXA, which will be the key to verify that the stamp duty side of things ties through with what you're doing in PEXA. So this will be done through some new batch type that we're going to introduce into RevNet. So we're actually introducing a concept of an e-conveyancing batch, which will have different attributes to the existing RevNet batches. Although from a change management perspective, it's going to be closely aligned with what you do now. So we don't view that there'll be too many major issues with using it. So today I wanted to discuss the actual system changes and the various components and try and give you an understanding of how the e-conveyancing will work in RevNet, particularly with the PEXA process. So I'll be talking through the changes RevenueSA has made to RevNet, the stamp duty verification, and the whole RevNet and the e-conveyancing process, and how they're going to fit together. So when we started looking at the project, so the initial question was, how much do we have to change RevNet? People have been using it now for 10 or more years, and yeah, we weren't sure how much we'd have to change it. So what we decided to do is actually recognise that we do need a different type of batch in RevNet, that the batch is going to need different characteristics, and that will assist both the clients and the revenue office in being able to differentiate between them. It'll give RevNet users a clearer visibility of their e-conveyancing documents as they go through the RevNet process. And at the same time, it will actually continue to follow the existing framework, so it'll be much easier for people to adapt to. Yeah, and it will also allow us to review the e-conveyancing process in RevNet. So obviously, you introduce functionality for an initial implementation. Part of that is reviewing and looking for where you need to make changes to meet the stakeholder requirements. So the first change you'll be noticing when you come into RevNet is a new column. You'll see that you can quite clearly see whether a batch is an e-conveyancing batch through the batch selection screen. There'll be an indicator on there. The indicator is not editable. There's too many differences in characteristics, and the process through RevNet, between RevNet and PEXA, is too different to make this a dynamic indicator. So I'll come to it later in the presentation, but it's quite important that before you go down this path in RevNet, you make sure that it is actually an e-conveyancing batch, because otherwise you'll end up having to do some voiding and changes through RevNet. You'll see here that you create the e-conveyancing batch through the same screen now that you create your normal batches. So yeah, this will open the e-conveyancing document process in RevNet. Clicking on this, we're going to give you a pop-up message, which might get a bit annoying after you've seen it a few times. Reason for that is because the batches are so different, and that if you go one way or the other and you go the wrong way, you're going to end up in a bit of trouble. In the ideal world, it'd be nice if we knew whether you were doing an e-conveyancing batch, but because of where the process might start, depending on which system you're going into first, we don't actually know that. So we've just put that up for users to make it a bit less likely that they'll create one in error. Once you've decided that you're going to create the batch, you'll come to the document data entry screen. Once again, it looks pretty similar. We have put e-conveyancing at the top of the screen, but you will notice that there's some difference in fields. So for e-conveyancing, we've removed the option of paying the LTO fees through RevNet. Well, they'll be paid through PEXA, so we're not going to let you pay them through RevNet because we don't want you to get into a position of paying them twice. You will, of course, still be able to pay LTO fees for non-e-conveyancing documents as you normally would. E-conveyancing batches can only actually have a single document in a batch. We thought it's a better fit with the PEXA process. It's a better alignment to do that. With the changes to stamp duty over the last 5 years, we found that most people create smaller batches anyway. The exception to this is if it is a Section 67 batch. So if it's got multiple documents that'll settle around the same time through Section 67, you'll still be able to put them in the batch. Once you've completed data entry and you calculate the document, RevNet generates a RevNet ID as it does now. And this is what you actually need to enter into PEXA to perform a stamp duty verification. So there's an interface which I'll get to later between the two systems, but you'll need to take note of your RevNet ID. So once you've confirmed the document, you no longer come to a nice stamping screen that tells you how many copies of your stamp and whether you're doing a manual or slip printer stamp. It's pretty simple, why not? Because there's nothing to actually stamp. So it'll be a change in process. The screen gives you the information that you need. We thought you might want to print a copy off and put it in the file for your clients, but also what's useful here is that it'll give you the RevNet ID. So that ID will be put into PEXA, and as I said, is the link between the two systems. And I guess it does highlight the reason why you need to know whether you're doing e-conveyancing or not, because you won't actually get to that screen to physically stamp your documents if you're putting it in an e-conveyancing batch. So once you continue along, we'll just have a look at the stamp duty payments, which is the other element related to the PEXA process. You can see by the diagram, there haven't actually been any changes made to stamp duty payments, so you will still continue to make your payments through RevNet at the time that it suits you. Yeah, so all the payments are still initiated by the RevNet user. There's no, you'll see in the PEXA presentation, you can disperse monies. The PEXA participant can still actually disperse the money through PEXA, but they'll be paying it to themselves, and then they'll be paying that through to us through RevNet like they are now. And of course, yeah, parties can pay their money however they want outside the PEXA system. To actually accommodate this change, to allow the money to come through PEXA, through the agent, to allow any clearing to take place, we've changed the overdue batch rules. So we will allow an extra 3 days once we get confirmation that the document's been electronically lodged through PEXA, for you to ensure that the funds have come through to your bank account and for you to end the batch in RevNet. And that's, of course, on top of the 9 days that's currently allowed. So just to summarise the RevNet changes for e-conveyancing batches, only certain document types are allowed. So you can't just put any documents into an e-conveyancing batch if we know that it's not going to end up being registerable through the Lands Titles Office. It won't be available in your document menu for e-conveyancing. You will only be able to get one document in a batch unless it's Section 67. You won't be provided to pay the LTO fees, and you won't be able to stamp your documents. So just to highlight here the importance of the RevNet ID. Once you see the PEXA demonstration, it'll be quite clear, but the RevNet ID is your key between PEXA and RevNet. So if there's any problems in the data belonging to the RevNet ID you're trying to enter, you will see errors appear in the PEXA space, and depending on the errors, you would actually have to fix them either in PEXA or in RevNet itself. Just touch on the stamp duty verification, and the verification is actually using the RevNet ID. You see here the 1 hour. There's a few automated verifications throughout the process. An hour before lodgement, with the scheduled lodgement through PEXA, we'll do an automated stamp duty verification. So we'll be checking at that time things like your documents not voided, key data elements match, and that we've got a valid RevNet ID so that there's a commitment for the stamp duty to be paid and that the document can settle. There are a lot of you can actually manually verify through PEXA, so you can trigger it in, of course, once you put the RevNet ID in initially to make sure that that's all being confirmed. And yeah, there are quite a number of automated verifications. The errors that you get, you'll see in PEXA. You won't see any errors in RevNet if you put an incorrect RevNet ID into PEXA. And the errors are supposed to be quite informative, so it should actually tell you what's wrong. For example, you're trying to put a voided RevNet ID into the PEXA system, which would mean that you either need to go and unvoid the document, or it means you've data entered a new document into RevNet and you then need to update the PEXA system with the correct RevNet ID. So just to summarise with RevNet and the e-conveyancing process, and I guess how these are going to fit together, there's a few keys to make sure that you do get this smooth transition between e-conveyancing and RevNet. The key one for me is to make sure that it's going to be an e-conveyancing document when you select it in an e-conveyancing batch and start the process off. So the things that you'd need to consider is it a document that can actually be self-determined in RevNet, which is most of the documents these days. You can certainly refer to the RevenueSA website and the guide notes to find out if it is a RevNet document. You need to also know that the other parties to the transactions are actually PEXA subscribers, and you do this through the PEXA workspace itself. So that has the capability of inviting other subscribers. I guess the message is you don't go and create your RevNet batch too early. The other question that you might want to ask yourself is, does the document actually need to be processed through RevNet? So at the moment, we have a lot of documents that come through RevNet that don't need to be stamped for stamp duty. And so that's really a matter of convenience. And probably the main one of these is the mortgages that a lot of people stamp. So they'll go through, mortgages are now exempt and don't need to be stamped. However, people put them through RevNet in order to pay the LTO fees. So it may be that you're actually needing to process less documents through RevNet if you are using the e-conveyancing process. Now, the other problem you may find is where the transaction falls outside. So you thought it was e-conveyancing, things were rolling along quite well, and it's no longer e-conveyancing. All you need to do then is to go and void the document and enter it into a non-e-conveyancing batch to avoid any of the problems that I mentioned before, which is the current functionality. As far as the change management of this goes, we've developed some e-conveyancing training. We'll be looking to publish it probably a week or two before the implementation date. We've also got some online help that will be available if anyone uses the online help now in RevNet. I know a lot of people have been using it for a long time, but there's a help button up in the top of the screen and you'll be able to go through there for any help that you need for the e-conveyancing batch process. We will be holding some webinars. So the webinars will be around the time of the actual business implementation date. So we're still waiting for waiting for the legislation to get passed. When that gets passed, we will be booking in those webinars. So yeah, we recommend if you don't already, if you haven't already joined the email subscriber service, you can actually do that now. You'll be notified of the webinars. But certainly we'll be focusing a lot on the system changes much closer to the implementation date, and to make sure that people know what they're doing once they go in and commence their PEXA batches in RevNet. So yeah, that's all from me. I'll hand over to Josh.
Thanks, Tom. Good afternoon. My name's Josh Radford. I'm an account executive at PEXA. Miriam Errington from Tuckfields recently wrote an article about the property reforms for the AIC's Conveyancing Voice. Not sure if you read the article, but it's a great article. And she quoted Steve Jobs within that article. And she said, "Great things in business are never done by one person. They're done by a team of people." And that is certainly the case here in South Australia. And PEXA are appreciative of the opportunity to be part of this industry-wide transformation and the session today. The level of collaboration between all bodies in SA has been excellent. We look forward to playing our role in facilitating electronic settlement. So where is PEXA today? We're scheduled to go live in South Australia in May, end of the month, maybe early June. 45 financial institutions are currently engaged, with Bank SA coming on board in May, June. We have over 2,200 plus practitioner firms which are active on the network today. Approximately 150, that should probably be 160 now, are in progress or inactive here in South Australia, and this is growing steadily. Over 120,000 transactions have been completed on the PEXA network, and over $14 billion worth of property value has been settled thus far. PEXA Direct, as Brenton alluded to, is our personal training program guiding South Australian practitioners. If there's one thing that we ask you to take from this presentation, it is knowing you'll be provided all the support and guidance so you can effectively transact online. Initially, we will have 2 PEXA Direct people here on the ground in Adelaide. They will be supported by our contact support team, which is available from 7 a.m. to 10 p.m. every day. The AIC South Australian training staff have just completed their PEXA training and are also ready to roll out a training program. I'm here in South Australia to offer additional support as well. And this is probably on the back of feedback we received, 6 to 9 months ago. The feedback from practitioners in other states was, hey PEXA, we require further support and guidance as this is a significant change and shouldn't be underestimated. We do appreciate that it is a significant change for everyone in the room, but we are listening to the feedback and we're here to provide that support for you guys going forward. From a user perspective, and something that you probably are all interested in, is there are different access levels within PEXA. And the flexibility is the key reasoning behind this. Whether you're a sole practitioner or part of a major law firm, we can ensure your current internal processes and approvals are catered for. We have the subscriber manager. This is your internal PEXA champion. It may be the business owner, it may be the managing partner. It's probably the person who signs the participation agreement within the company or the firm. The subscriber administrator may be the same person in a smaller organisation. In a larger business, this role may be someone else who can release any administrative burden on the subscriber manager by setting up users, running reports, etc. And a user is anyone who needs access to PEXA, needs to be set up as a user. Signing permissions can be granted as per your internal processes. We receive a lot of feedback around signing within PEXA, and I'll touch on that now around signing and security. All users set up in PEXA with the right to sign need to have a digital signing certificate, which is like a USB token, as you can see there in the picture. There are 3 main layers of security which is in place. Number 1, to get access to the PEXA platform, you need a PEXA login and a password as a registered user. 2, each person with the right to sign in the organisation will need a physical USB token which is encrypted to that individual. And thirdly, to digitally sign, you then enter a personal, unique 6-digit PIN number that only you know. Robust security measures are in place. PEXA will also cross-check financial signatories within PEXA with a corresponding bank as well to ensure they can authorise funds and the movement of any money. I will now demonstrate the PEXA workspace for you, as I'm sure you're all very interested. Before I commence the demonstration, a key point to note is PEXA is the front end into the land registry and RevNet. We are all integrated. So it probably made sense me going third after Brenton and also Tom. As I progress through the demonstration, I will call out SALIS and RevNet and how all three parties interact to ensure electronic settlement can occur. Okay, first landing page on PEXA when you log in is your dashboard. This acts as your catalogue for all your property matters. And you'll hear the term workspace. That refers to a property matter. And you'll have a workspace for every separate property matter. Within your PEXA workspace, you will have a summary tab. Here we are ready stage. And this is where you want to get to within PEXA when you're doing a settlement. We have two bars, and what they mean is the lodgement bar means all documents are prepared and have been signed. And the appropriate checks and calls are made with SALIS to ensure this is in a registrable format, which will be accepted by the Land Titles Office and not fall into requisition. In terms of the financial settlement bar, this means that all monies are available, being pledged by the correct participants, and everything balances around source funds and destination funds. I'll get to those shortly. What we recommend within PEXA is working in this blue bar down the left-hand side, working from top to bottom. It's a good workflow process to follow. The first thing you do within PEXA is enter your land title reference number or folio number for the property. This will then, through our integration with SALIS, pull all the information from SALIS into the PEXA workspace. So here we can see the address, the property description, who the proprietors on title are, and down the bottom, something I want to highlight is the title activity check. It acts as your check search. You will be notified if any changes or activity has happened on that title. This happens every week automatically prior to settlement. In the last week prior to settlement, this happens every day. And on the day of settlement, which can be any day of the week in PEXA, it happens an hour prior to settlement. This happens automatically, but you can also do this manually whenever you want within PEXA platform as well. So working down the left-hand side, we'll click on participants. Here we can see the parties within the transaction. So we have Kakadu Property Law, representing the proprietors on title, being the vendor, or the seller, being Margaret Black and Maxwell. If we scroll down, we can see Whitehaven Conveyancing Services as the PEXA subscriber, representing Amanda and William Wakefield as the incoming proprietor or the purchaser. This is obviously a cash transaction, for there are no banks involved in this transaction. If there was a mortgage on title or a bank loan, you would obviously see the banks in this workspace as well. So all parties within the workspace share the one workspace, and this creates greater transparency of what's happening. Documents. So this is where the purchaser will create the transfer of land document. And as we can see here, it has been signed. We can also see verification results being successful. And this is a real key within PEXA, is lodgement verification. So at the moment in the paper world, you go down to Grenfell Street, 11:30 on a Friday, and you're hoping all parties turn up, and you're hoping that all parties have the correct documentation and everything matches. But you're never quite 100% sure. What this allows you to do is this is making the appropriate checks to SALIS and ensuring that the documents in a registrable format, which SALIS and the Land Registry will accept at time of settlement. You can see 0 errors and 0 warnings. You can also see the land title reference number, the property address, and who signed the document with their digital certificate and at what time. we go into the settlement. This is the financial settlement schedule or the monetary aspect of the PEXA workspace. And this is where source funds must balance with destination funds in order for us to get to the ready stage. So if we click on source funds first, we can see it's a cash transaction, so we can see purchases equity here. And we can see destination funds. Here we can see all the line items or disbursements involved in the settlement. As Tom pointed out, stamp duty will populate in here. We also have council rates, water rates, your professional fees, the vendor's funds, PEXA fees. And in the paper world, this would obviously involve numerous bank checks. Within PEXA, this all happens electronically. So if we go to the settlement summary, we can see financial settlement summary balanced, which means, you know, we won't get to settlement and have too less funds, not enough funds, or surplus funds. We will have the correct amount. This is the part where Tom alluded to with RevNet and our integration with the RevNet. So you can see the RevNet ID here. And you'll populate this workspace with the RevNet ID. So as you will today, you go into RevNet to calculate your duty. There you'll get your RevNet ID and you'll populate the PEXA workspace. Through our integration, this will pull the stamp duty amount into the financial schedule to ensure everything balances correctly. Conversations. This is something where we receive a lot of positive feedback from practitioners. And what this means is you can communicate with all other parties within the transaction, whether it's the banks or whether it's the other legal practitioner. So gone are the days of being on the phone for 45 minutes, an hour on hold with the banks. No longer, you can communicate via this channel. And you'll be hopefully guaranteed a quick response. Notifications and history log all key events within the PEXA transaction to ensure you have all records of all events within PEXA. So we'll go back to the workspace summary and see we're at ready stage. Settlement date and time arrives. As I said earlier, that could be any day of the week or any time. You have that flexibility within PEXA because you don't have to attend settlement. So let's click to initiate settlement, which you don't have to do in a PEXA transaction. Once you're at ready stage, this will just happen automatically. So what happens at settlement? The workspace locks and things start moving. So on average, funds are in bank accounts within 30 minutes, as opposed to 3 to 5 business days waiting for bank checks to clear. The purchaser will have their name on title almost instantaneous, and the vendor has their funds, and you will have also your professional fees as well. Done. Just click out of this. So that's a workspace demonstration. It was pretty quick, but that's how easy it is to use PEXA. Just finally, the network does continue to grow. If you're not on board, we encourage you to register. There's no cost to register on PEXA. And many of your peers, perhaps the people sitting next to you, are already active and ready to transact and enjoy some of these efficiencies. I'll be available post-session, and I know there are a number of representatives here from PEXA also who will be happy to take any of your questions. I encourage you to ask any question you're thinking about, because as I mentioned earlier, we're here to support everyone here. Thank you for your time.
Thanks, Josh. Okay, so by now, many of you are new to the reforms, and some of you who are not are probably wondering if and how you're going to cope with these reforms. And some of you are also wondering whether you're going to play in the electronic space, because that involves an additional degree of difficulty. But you need to bear in mind, of course, that you won't be playing electronic space, at least not for the next few months. However, you must, in fact, deal with all the reforms and change your practices within the next few months if you wish to be in business as a conveyancer or do conveyancing work by the end of 2016. You cannot hide in paper. My friend from law school, Philip Page, and I are now going to talk about some practical issues for practitioners going forward. When we use the term conveyancer, we're using it in the generic sense, meaning a legal practitioner or a registered conveyancer. But first, of course, the disclaimer. The contents of this presentation are for general information only. They are not intended as legal advice and must not be relied upon as such. Conveyancing practices and requirements for specific situations may vary substantially. Participants should familiarise themselves with the relevant requirements and obtain their own detailed legal advice before implementing any of the measures discussed in this material. The mandatory disclaimer. So what are Philip and I going to be talking about in the next half hour? Well, we're going to be talking about compliance and structure, the need for a change champion, talking about risks, talking about external communications, which will be critical, as well as, of course, precedents, work templates and workflow. And this is, of course, just a summary of these issues. First of all, let's talk about compliance and structure. Now, if you haven't already understood, these reforms apply to both paper and electronic transactions. The reforms are made to paper. So if you don't want to play in the electronic space, that's fine, but you'll still have to change your processes because these reforms apply to paper. But what the reforms do is they enable people to undertake electronic transactions if they wish. So there's one basic process for paper and electronic, which you'll need to follow. These changes to your processes will be required even if you're not going to do electronic transactions. One of the things that I'd like to highlight at this point is that the reforms in fact constitute the conveyancer as the gatekeeper. Now, in the past, the Lands Titles Office has been the gatekeeper in relation to some aspects of conveyancing transactions. However, these reforms in fact drive it back so that you now become the gatekeeper for most of most parts of the transaction. And that's because you certify in relation to the processes that you've undertaken. You certify in relation to what you've done and about your client. So to give those certifications, you need to make changes to the conveyancing process, right back, in fact, to the first touch point. And we'll come back to that in a minute. And I see that my slide hasn't worked very well. So let's go to the bottom because that's going to be easier. The certifications drive changes into the conveyancing process and they require changes from the first touch point. So each conveyancer must certify in relation to identity, that you've taken reasonable steps to verify your client's identity. About authority, that you hold a completed signed client authorization, and that in fact links to the verification of authority. that you've retained evidence. It's about evidence, that you've retained supporting evidence in relation to your certifications and the client authorisation. And finally, about correctness, that you've taken reasonable steps to ensure the instrument is correct and compliant with all applicable legislation. And as I said, you then give certifications which drive those changes back into your conveyancing process. And in fact, you need to therefore think about this from the very first touch point. So this has implications for internal structures. The evidence supporting the certifications and the client authorisation must be retained for at least 7 years. That's 7 years from the date of lodgement of the last instrument to which it relates. So the processes require structure around you gathering that evidence. And that's especially the case in relation to client authorisations, verification of identity and verification of authority, VOI and VOA. So where this leads us, of course, is that you need to review the responsibilities. Who undertakes what parts of the process and who monitors those processes? About who performs critical activities, who signs instruments, authorises payments, etc. And again, I stress that we're talking about paper as well as, if appropriate, electronic. If you want to play in the PEXA space, then you'll need to review your structure as part of a preliminary to registration with PEXA. You need to review it in relation to persons and also in relation to authorities and permissions, the people who are actually going to do the relevant parts of the process. Now, if it hasn't already struck you, what you need to do is appoint a change champion. Now, I talk about a change champion because it's not just a change manager, because we need some enthusiasm around this, because many people do not like change, and so we need somebody who's going to be enthusiastic within the office to drive this. That person may well be you. The reason why we need a change champion is because we've started on a process. Now, this process has been going on for, Brenton said 2 years, I would say it's been going on since before 2000. Right? And this process is going to continue. Major change. I will tell you that not a week goes by without there being another development, a change, a new process, something new. And so we need somebody who's going to have it as their job to monitor the changes. The MPR, the model participation rules, the guidance notes issued by ARNEC, Australian Registrar's National Electronic Conveyancing Council. Locally, the regulations under the Real Property Act, the Registrar General's participation rules, his requirements and the guidelines, they will keep changing. If the model participation rules change, as they will, they'll be reviewed in another 12 months at least, then because of alignment, that means that the processes here will need to, and the documents here will need to change as well. So we're going to see this continual change for the next at least 2 or 3 years. So somebody's got to be responsible for being on top of that. There's the alignment of the manual process for electronic conveyancing, which is being staged into state. And so as it's being staged into state, they will then think about it and realise that things could be done a bit better, particularly I think in relation to priority notices. And so that will then drive further change. No, they're not doing verification of identity in New South Wales, for example, yet. They're not doing the verification of authority in New South Wales yet, except in electronic. And of course, few people at the moment are doing electronic transactions interstate. So as this alignment occurs, we will see these changes being rolling through in South Australia. Priority notices, Brenton mentioned, are being introduced in New South Wales and Victoria, and that will, I think, lead to some change. The reforms in electronic conveyancing are a huge opportunity for practitioners to gain, maintain, or lose the competitive edge. If you don't have a change champion, then that will be lost. Those changes are happening, of course, locally and nationally. So for those who are practicing beyond South Australia, then it becomes particularly relevant because we're going to see practitioners coming from interstate to try and take our work. So part of appointing the manager and change champion means that we need to undertake an analysis of our businesses. And I suggest you and that change is required, I think, starting now. That analysis should be done, I suggest, as a TOWS. That's SWOT backwards. And I'm sure everybody's familiar with SWOT. But if you do it as a TOWS, the focus of that analysis, in fact, changes subtly, but I think importantly. You'll then need to develop objectives, review your processes, and develop an action plan to implement in your business. That involves preparing and monitoring new and revised protocols, checklists, precedents, and templates. And then, of course, the change champion will have to undertake and supervise the implementation and training of staff. Then monitor the changes and then keep the staff informed of the changes as they occur. It's a significant job, and if somebody is not given this job, then it is unlikely to happen. Certainly won't happen smoothly. And the consequences we know of for businesses can be quite dire. So I'll now pass over to Philip Page, who's going to talk to you about risk. I'll be back in a minute.
Thanks, Jeffrey, and hello, everyone. Yes, I'm saying a few words about the happy topic of risk, something that has always been part of conveyancing practice, but with these reforms and particularly with electronic conveyancing, there's definitely a potential for substantial increase in risk. There's a couple of different kinds of areas in which risk is particularly likely to occur. One of them is basically lack of knowledge about the reforms and information to actually carry on business as a conveyancer in the light of the new changes. So one of the things that we have to do is obviously gain knowledge of the new required processes, and Jeffrey's touched on the need to keep abreast of changes. We also obviously need to change our own internal processes to cope with the new systems and train our staff and keep them trained, keep them informed of changes as they occur as well. We also need to communicate vital information to our clients. Clients, of course, are going to have no way of knowing about these significant changes unless we tell them. They'll probably still be looking for duplicate certificates of title. They'll be expecting to sign transfers, especially if they've dealt with land before. So we'll need to make them aware of the fact that they'll now be signing client authorizations and will be signing transfers on their behalf. So this is another significant change that we have to grapple with. The other major area of risk is increased exposure to potential fraud and technical problems, systems, equipment and data, attack, theft or failure. Because of course in the electronic world, whether we're actually dealing with electronic conveyancing or not, we still deal electronically to a large extent, and this exposes us to the risk of in that area, and I'll deal with that a bit more in a moment. Conveyancers are obviously increasingly the target of various kinds of fraud and malicious activity. And the reason for that is that we hold valuable information. And ever since, or particularly I suppose since verification of authority came in, we've been holding a lot more personal information belonging to our clients in the form of details of their passports, driver's licenses, their dates of birth, information that would be extremely valuable to someone who wants to create fraudulent identities, potentially. We also hold our clients' bank information, our own bank information, and password access to the information within our own systems. The transactional equipment that we use to transact electronically, the computers, the USBs, the PEXA tokens, iPhones, post-it notes, all of those things may be subject to either failure or getting into the wrong hands and being used to, or in a fraudulent way. I mean, the information, the items could be stolen, passwords could be compromised. It's probably not uncommon for people to have passwords for their computers written on post-it notes and stuck on the screen of their computers. Obviously, that's an extremely dangerous practice. There are, I think at the moment, there are steps that we all need to take to tighten up our internal office security to minimise these risks. Just looking at the particular forms of electronic risk, data theft, hackers, obviously hacking into computer systems is something that we all have to live with these days. No matter how secure the systems are, hackers seem to devise ways into them. Trojan horses, interceptors, our own staff might be employed by some agency who's using them as an agent to gain information from our office. Cleaners. There are many possibilities of ways in which this information could be compromised. And then there's the technical problems of data destruction or corruption, whether it's deliberate or whether it's just as a result of system failure. And these things happen all the time. So it's essential that we have appropriate safeguards and backups to minimise the damage that might be caused by them. Also, extortion and data lockout is becoming a more common factor of practice these days. It's known as ransomware actually, where for some reason information gets onto your computer, which enables remote parties to basically lock up your information so that you can't access it unless you pay them money. That sort of practice has become fairly common in Australia. It's certainly affected a number of law firms around the place. So the need to protect our own systems by having appropriate software that protects the system from invasion by electronic attack is essential. The other area of risk is in the process of verification of identity and authority, where clients may potentially produce false ID documents. There's also the fact that we receive quite often the identity information electronically and we store it electronically. So it's all bound up in the need for security. And other risks in the general environment and general cyber threats as well. These days, basically, to practice conveyancing requires some exposure to these risks. We can't practice conveyancing without exposure to these electronic risks, because it's just part of modern electronic conveyancing. And when I say that, I don't mean purely electronic conveyancing of the PEXA kind. I mean conveyancing which is still involves a fair amount of electronic activity. And that is increasing because a lot of the information we get these days is via websites or links. So just to run our ordinary practices, emails and data from various websites, we are using electronic means. And obviously SALIS itself is one of those areas where we obtain electronic information. Contracts and notices are increasingly being served electronically, and there's increasing push to make that happen even more, with the possibility of clients actually signing electronically on their purchase contracts. So that this is all exposing us to increased risk. Identity agent reports, where we use someone like Australia Post or ID Secure, the information that we get is via electronic reports. And obviously electronic conveyancing, if you actually practice in that, and if you wish to participate in it, will involve even more importantly dealing electronically. So what can we do about this? Obviously we have to, having identified the areas of risk, we need to identify the targets, the sources and the nature of the risks and threats. Take into account that they could include external access and plugins from external computers. Some of you may work from home with links to your office computer. You may be on a network that extends to remote locations. The computer that's used at home might also be used by the children. Little Johnny might download all sorts of interesting information on the same computer. He might inadvertently download some sort of malware that may find its way into your office computer as well. So obviously if you need to ensure that similar protections are provided on all of your home computers if they're linked to the office computer, in the same way as you would need to with your own office computers as well. You need to develop a detailed plan and protocols to counter these risks and implement active steps to minimise the risks. And obviously this needs to involve all staff, and especially perhaps staff who work remotely as well, and not forget them, and not think that just because they're not working within the office that that you don't need to worry about the security of their computers. And when I say computers, of course, I'm not just talking about computers in the traditional sense. So obviously it also includes iPhones and tablets and similar equipment. So you need to ensure that the antivirus and anti-malware software in all of those items of electronic equipment is as good as the office system. Now, the other aspect that I wanted to speak to you about, the other form of risk, is privacy and security, because conveyancers now are receiving and storing much more client personal information. And I touched on that earlier. So we obviously need to develop and enforce protocols to deal with the way in which we handle and store that personal information. And that may vary depending on whether the file is still live or whether it's being archived. Obviously, while the file is live, you need to have robust protective software. That's absolutely critical. And when the file is archived, and you've heard that it will need to be stored for at least 7 years, it needs to be in a locked facility with no connection to the internet so that it's protected from potential hacking and corruption. And you also need to have appropriate means for retrieval and return of the information when it's required. The Privacy Act, some may think it only applies to businesses with a turnover of more than $3 million, but in fact it also applies to businesses that are in, where it's part of your business to deal with personal information. And I think it can't be said now that conveyancers are in any way exempt from the Privacy Act, whether their turnover is over or less than $3 million. It's definitely applicable to conveyancers because of their of the essential dealing with client personal information as part of their business. So that means that the obligations under the Privacy Act are going to be applicable to you no matter the size of your business, and that includes protecting that personal information from unauthorised access or disclosure. And if anything, the restrictions on how you deal with personal information are going to increase over time. That's certainly been the historical, or the history of that area. And clients obviously also expect you to keep their information secure and free from corruption or from being able to be gathered by anyone else who's unauthorised to receive it. And also that you shouldn't use it improperly or sell it to other parties or facilitate that happening by anyone else. So you need to create and enforce a privacy policy, and the guidelines for doing that are set out under the Privacy Act. You can obtain them from the Privacy or Information Commissioner's Privacy Management Framework on the website of the Privacy Commission. And that also sets out steps to comply with the Australian privacy principles, which are something that you're also going to have to grapple with if you haven't already, because it is now an essential part of conveyancing practice. And on that note, I'll hand back to Jeffrey.
Thank you, Philip. Okay, so moving right along. The reforms require us not just to change what we do internally, but also externally. As I mentioned a bit earlier, really it requires that you start from the first touch point, because as somebody else observed, our clients know nothing about these changes. And as a consequence, if we don't start telling them at the first possibility, then they'll be progressing on the same basis as they transacted previously. So they're not going to be expecting to, they're going to be expecting to sign a transfer, and they're going to be expecting to do a whole lot of other things that they do presently. So what that leads us to is that our communications must change. Clients will be unaware that you'll be signing the instrument, whether it's in paper or electronic. That their identity must be verified with documents at an interview. That their authority, the right to deal and their capacity to deal must be verified. That there's a form, a prescribed client authorization that will need to be signed by them. That documents will have to be produced, original documents will need to be produced to you and that you need to copy and retain them for at least 7 years. That priority notices may be issued. The duplicate CTs are going to be abolished or have been abolished, depending on when the communication goes. And finally, that settlement and lodgement may be effected electronically. Right? So if electronic settlement is within the possibilities, then of course you'll need to discuss the advantages and disadvantages. So the external communications must inform clients of the changes, and I suggest this is what you need to address from the very first touch point. You need to review your letters, your emails, your website, and you'll need to include the professional requirements like fee disclosures. You'll need to train your staff too, because they'll be discussing these matters with your clients. If they're not across this, then it's likely that something will be said that's not correct, not up to date. I suggest you also want to provide contacts for questions, because somebody who's expert across this, these reforms must be available to discuss those issues with them. I suggest also that you provide useful information on your website, and also provide links that will to other websites that will confirm the information that you're passing on to your client. I mean, paranoia will kick into some of them as soon as they hear that you're going to be signing the transfer. So you want to be able to provide them with links where they can confirm that what you've actually told them is correct. Now that's a brief summary of the external communications, but of course you'll need to change things internally as well. You'll need to review all your precedents and your templates. Review and develop customised precedents and templates. These are for your communications, internal and external. Precedent documents, including contractual terms, financial statement and calculators if you've got inbuilt calculators. And of course, because the fees there is an additional fee to be used if you play in electronic space, there's a PEXA fee that's payable. Then you can see that the paper channel and the electronic channel may have fee differentials. Also, the work that's required for paper may end up being a little bit different to the work required and the time required to play in electronic space. So I think you'll need to review your the costs in both those areas so that you can in fact disclose that. If you're using proprietary conveyancing software, then of course there are some issues that need to be addressed there. You'll need to check with the provider about the changes and their timing to ensure that you know what documents are being changed, what, say, electronic statements are being changed, to incorporate that within your processes. In addition, you've got to look at your workflow tasks and timing, because they will change. You'll need to incorporate the lodging of priority notices. That's an issue for timing and pre-settlement checks. Now, it may be that you think, oh, because priority notices are optional, that it won't be necessary for you to do them. However, I suggest to you that it may well be that priority notices, once the duplicate CT has been abolished, may be insisted upon. I think it's likely that they will be insisted upon by the incoming bank. The other issue around that is you need to check that the priority notice that has been lodged matches the documents that you intend to lodge, whether it's electronic or in paper. Because if you recall, priority notices must specify the documents in the order that they're going to be lodged, and the priority only comes if you lodge all those documents in that order. You also need to ensure, of course, that the names are precisely correct. You need to incorporate in your workflow the verification of identity and verification of authority checks and checks and documents before you certify them. You must check the documents before you certify, you give the certification on the instrument. You also need to build in timing for signing of the client authorization, and again, checks that you've got that document if it doesn't happen at an interview at which you are present. You want to check the signatures on that as well. You'll need to check that you've got all supporting evidence that you've collected and that you've stored it, because you've got to give a certification in relation to that too. Also need to build in timing of the request and receipt of funds. Bear in mind that more and more you're going to be receiving these funds electronically. So it's critical that you have a system built in that checks that that money has been received into your trust account, or if it's going into the PEXA source account, then it's been received there. You don't want to settle with it unless you've got that money, do you? Also incorporate the readiness for the signing and certifying of the instrument. And if you're going to have a electronic transfer or specify electronic transfer of funds to your client, then you want somebody to come along and check that you've actually keyed in the right numbers for that for the account that's going to receive it. In PEXA, various accounts are already inbuilt. So if you're going to pay a particular bank, then those accounts are already inbuilt. But if you're going to send the money to a client, then you'll need to ensure that the account details are put in accurately. So what I'm suggesting is that somebody needs to check that the numbers that have been input are correct. It's critical, I think, for smooth flow to develop detailed checklists for file activities. This is not just for the workflow, of course, because what it also does is it provides evidence going forward that you've actually gone through that process. So that in 7 years' time, if it all goes pear-shaped, then you can pull out a contemporaneous document that showed that, yes, you were recording that you did these things. You need to review and develop protocols for verification of identity interview, which incorporate the signing of the client authorization at that interview, if at all possible. And of course, that includes using an identity agent, if indeed an identity agent is to be used. Protocols about the collection and storage of evidence supporting the certifications. You'll need to review your trust account arrangements. Who are the signatories, the number to sign. And of course, these are required for registration in PEXA. If it's going to be a transaction that may settle electronically, then there'll need to be new contractual provisions. The Law Society and the Australian Institute of Conveyancers are reviewing our contracts to include special provisions to enable electronic conveyancing to occur. There are special requirements that are required, special changes that are necessary to enable electronic conveyancing to occur. If you get a contract in that's been negotiated by somebody else, then, and it's possible that it may settle electronically, and then of course you need to check that contract to ensure that those provisions have been incorporated, and if not, then there'll need to be a variation. Now, Brenton has talked about some transitional requirements, and I'll just go through them very quickly. The transitional period is 4 months, and so normally that's the 4th of October. So during the transitional period, you may lodge instruments in the old or the new format. That format determines the signing, the witnessing, and the certification that appears on the instrument. But you also need to phase in the new requirements in anticipation. If indeed you wait until a month before the end of the transitional period, then I'm very confident that you'll develop problems because it will not settle within the transitional period. If you're using the old format, that's fine. You need to follow the existing requirements. If you're going to use the new format, then of course you'll require a client authorization signed by your client, and subsequently, it doesn't have to happen at the same time, but signed also by you or somebody on your behalf. And all the other reforms need to be implemented as well. So you will need to have gone through the verification of identity, the verification of authority, retain the evidence, etc. All those things are wrapped up in the certifications that you give on the instrument. And of course, if you're using the new format, then you'll be signing it on behalf of your client. Now, whether there'll be a hybrid of old format and new format is possible during the transitional period is a matter that still hasn't been determined. Brenton referred to that a bit earlier. So watch this space. There'll be a notice to lodging parties that will in fact detail those things. After the transitional period, you must lodge in the new format. All the reforms apply. The Registrar General has a discretion to accept the old format, but of course, you'll need to provide some evidence, a letter explaining why the new format could not be used. So if you've got a transfer already in your office signed by the parties or whatever, then that's fine. You'll have an explanation. But if indeed the transfer is signed 2 weeks before the end of the transitional period, then you might find that the document will be rejected. Another point during the transitional arrangement, we need to check the register for encumbrances. The register has always been the source of information since 1858. But of course, with the encumbrance panel being removed from transfers and other instruments, it becomes critical that you check the register for details of the encumbrances. Okay, now, Brenton mentioned, and I'm going to just go through it again, detailed professional development is being provided to people on the reforms. We're running Real Property Act alignment series. We're in the middle of those, seminars and best practice groups. And if you want details about that, you can go to arcsa.com.au. The Law Society is conducting seminars which are yet to be scheduled. They're waiting until the implementation has occurred. There's also detailed training to be done in relation to the PEXA platform, which is a totally separate exercise. AICSA is going to conduct hands-on training in a computer suite so that people can literally go through the whole process. Also, if you go to the PEXA website, there are tutorials and videos that you can look at. However, be aware that some of those relate to particular jurisdictions. So it could be that a particular webinar relates to, say, a transaction in Queensland. Something to look at. Also, AICSA is preparing a manual in relation to these reforms. Here's a list of various websites where you can gather information. It's alphabetical. You'll find most of the information that we've talked about today and that you will need in these links, whether it's information from ARNEC, from the Registrar General in relation to documents, Law Society, forms online, etc. So I think we're now on to the Q&A. Thank you.
Thank you, panelists. Now it's the Q&A time. My name is Matt Gillett. I'm from PEXA. I'll have a roving mic, so I encourage you to compile your questions and direct them towards any members of the panel, be it from a practice perspective as a conveyancer or a lawyer. Any questions about PEXA? I'd just like to introduce Amy Garrity, who's a property lawyer and senior legal counsel at PEXA. Any RevNet questions or any questions for the registrar? So can I get a lead off? Can I get a lead off hitter? I'll have to ask those who are sitting on the window to participate with the mic because it may not stretch down the. All right, well, I'll get started. I might ask the gentleman down the end, Jeffrey and Philip, with the information that you shared today, thinking about, I suppose, Philip, in your own practice, what are the things that you're doing right now in preparation for these reforms?
Well, I can say that we have now actually registered with PEXA, so that's been a big step and quite a process, but it's been achieved. So we're looking forward to being able to actually incorporate that as part of our dealings once it's available. Apart from that, it's a matter of really just implementing the things that we've been talking about today, training staff, being aware of the way in which clients need to be informed of the changes, and upgrading our security of our systems as well. So all of the things that we've heard about today are certainly being grappled with.
Excellent. Josh, do you have it on the back?
Yes, thank you. Just a query that when looking at these panels where you put your information in, where the parties are, could be third parties such as custodial trusts or people in that order. I know it's obviously been accounted for. Are they set boxes where it's not going to be going on to the title itself or in the information for registration of title, but they'll be recorded that they're holding in a capacity as a custodial trust or some form of trusteeship? I'm just wondering where that's going to be going to. And following on from there, similarly about names, Brenton's looking up here, puzzled I can see, but stat decks where it involves with change of names, because we'll be signing everything, so are they going by the wayside?
So the first question I'll direct to you, Amy, just regarding inputted names and the holdings.
Okay, so we do have screens where you'll capture party information, such as are you acting as the trustee of the trust, and they won't pass through onto instruments. But yes, if you've got that information and you want to, or you're required to enter it there for, under your existing requirements, then they'll be available there, those fields. Change of name, if you're wanting to lodge a change of name as an instrument on its own, then no, we don't have that. We've got doing justifications. No, okay, sorry.
In regards to the need for a declaration, Tony, I've finally given in to your requests over 5 or 6 years of badgering me to death. And change your names, you are right, because you are giving a certificate that says you have the evidence that allows you can lodge. The need for a declaration in a change of name will be the subject of a notice lodging party, and it won't be required. You'll just give a certificate saying you're satisfied, etc., and the change of name will come in. No need to do the declaration. We're reviewing the use of declarations across a number of other documents as well. We've just started that, so watch this space. But in regards to change of name, Tony, declarations will no longer be required post bill.
Josh, down the front.
What will the PEXA fees be, and is this a fee that can be passed on to the client as part of the conveyancing?
So the PEXA fees are on the PEXA website, and they vary depending on what the transaction is that you're doing. So if we're talking about a transfer, it's $106.26, including GST. So there's one of those on the seller side and one of those on the purchaser side. You would have seen when Josh did the demonstration that there's a schedule where all of the fees go out and other payments go out on the destination side, and then the money that comes in on the source side has to come from a known source. So it may come from the loan funds from the bank, which means it's the buyer's money anyway, or the seller's. If it's or it may come from the practitioner's trust account if you're putting funds in. And when I say it's the buyer's money or the seller's money, it's either coming out of deducted off what the buyer is paying to the seller, or the buyer's putting in an extra $106.26 for their own fee. So that's really coming out of their own money or their own loan funds. If you're lodging a caveat, for example, then those fees would be direct debited from your own account, and then it's a matter for you whether you're going to recover those or how you're going to treat those between you and your client. Sorry? Yeah, for any lodgement. So if there's financial settlement in the workspace and money's going through PEXA, then the fees just appear there as line items out of the client's money. Anything that's lodgement only is direct debited from your account, and then it's up to you to do what you want to do with that. And there's a full list of fees on the website, and they're all there and available.
Roger?
Who's working at this? The client authority, I know that when I witness the documents being signed, my VOI, I sign off as subscriber. I've appointed ID Secure. Do they sign as witness as the subscriber in the subscriber section of the CA? Or does that come back to me to sign on after they've done their VOI?
I'm not sure of the service that any of those identity agents are providing, Rog, so I can't really comment. It says that you must take reasonable steps. So in an ideal world, the VOI and the CA are absolutely linked, because otherwise you could say there's a break between the VOI and the authority, and is that reasonable is not for me to determine, it's for you to determine with working your clients. So to mitigate whatever risk there may exist in that, do them simultaneously. But the law doesn't prevent you from doing them separate, as long as you've taken reasonable steps to satisfy yourself that the person who the VOI was undertaken on is the one and the same person standing in front of you who also is attached to the parcel of land you're transacting on. I can see Sean from Zip ID down the back. He might be able to answer from an identity agent's perspective.
Would be signed in the presence of the face-to-face VOI query by the client, and then the CA form would be signed in the bottom right by Zip ID as identity agent. That obviates the need for you to sign as subscriber on the bottom right.
Yep.
And they would be returned to you as one parcel, effectively the VOI plus the signed CA.
Simultaneous.
All right, just to repeat that for those who didn't capture, there's a space on the client authorisation form for the agent of the lawyer conveyancer to sign should they be performing the face-to-face interview and completing the client authorisation.
Can I just add something there, and that is that somebody can sign the client authorisation on your behalf if you authorise them. So that could be somebody within your office. It doesn't have to be you. It could be somebody within your office, or you could authorise a identity agent, for example, to sign on your behalf. And if the client authorisation is being signed remotely, in other words, not before you or before your staff, then it may well be desirable for that identity agent to sign the client authorisation at that time, because the client's going to come in, they're going to sign the client authorisation there and then. So it's desirable that somebody signs at that same time, at that interview, to confirm that, yes, it was signed by this person or these people at that time, because there's no witnessing of the signature of the person, the client signing the client authorisation. So the fact that the identity agent or whoever signs at the same time that the client signs at that VOI interview may become important if it all goes pear-shaped later.
Yeah, just wondering, with electronic conveyancing, is there an option to do it outside PEXA? And what about people who don't want to use conveyancers? I understand there's always has to be that option that they can do that, and how does that fit in with the process?
So that wouldn't be an option in PEXA. At the moment, PEXA is the only ELNO, so the only electronic lodgement network operator currently in 4 states, moving into South Australia. So if you want to settle electronically, for now, it's PEXA or you're not electronic. And we don't register people to go in and do their own conveyancing. So they're using a lawyer or a conveyancer who's registered, where we've done all of our VOIs and checked, conveyancing licenses or practicing certificates, and that everybody meets all of the requirements to join the network.
Self-represented parties are still dealt with both in the VOI requirements and the Act in regards to verification of authority. So self-represented parties are very much still part of the broader Real Property Act.
One of the critical aspects, I think, of electronic conveyancing is that it's a closed system like the ASX. So only certain people who have gone through a process can access that. So your clients cannot access it unless they are admitted as subscribers to PEXA. So the only people that can transact through PEXA are ADIs and some other financial institutions, legal practitioners, conveyancers, some government people, obviously the revenue authorities, the land registries, and that's about all. Does anybody else?
Yeah, look, if you had clients who were large enough to meet our eligibility criteria, so meet the insurance rules and have insurance, of a fairly significant level, then yes, they could join as principal purely to do their own transactions. So, that might be a property developer, for example, and, government bodies who want to go in and lodge certain instruments, so caveats, certainly could meet the criteria, but your mums and dads for conveyancing are just not going to meet those requirements.
There's a question down the back, the gentleman with the glasses.
Yeah, hi. Costs involved in this. I'm looking at PI insurance, first of all, Jeffrey. How's that going to be impacted by this new legislation, which seems to throw the risk directly back on us? Have you had discussions with our PI insurer? Secondly, where did the 7 years storage come from? There's another cost aspect for us. And thirdly, duplication. I noticed that if I go into PEXA, a title is generated. There's a cost there. If I have to do searches through Salus, there's a cost there for the same sort of information. Has there been some discussion about duplication of that sort of information? Because there's extra costs there.
So there's a few questions there. Maybe first
start
about PI, Jeffrey.
In relation to professional indemnity insurance, the insurer for the conveyances scheme has made it quite clear that they will not, in fact, be increasing their premiums as a consequence of people playing electronic space. However, they will increase the premiums if indeed there are significant claims. So this has been discussed with the insurers over several years because it was an important issue for us. But it's been made fundamentally clear that there will not be any increase of premiums for conveyancers, for registered conveyancers. In fact, the insurer has formed the view, and this is nationally, that electronic conveyancing itself probably makes the process of conveyancing less risky in the respect that we're verifying our clients, their identity and their authority, which some conveyancers aren't doing at the moment. So I don't expect premiums to go up unless claims come, and then that's just a matter of there are claims, therefore the insurer needs to recover. The second question was
about the 7-year archiving. Brenton, I'll direct that one to you.
Firstly, and people would have heard me before, I don't think there's any shift to responsibility or risk in regards to the codification of the certification. I've always taken the view that when you certify something true and correct pursuant to the Real Property Act, if I say in the old way, that absolutely went to the heart of your ability to act for your client. And for me, as a statutory officer regulating that, you cannot do that if you haven't identified them and attached them to some extent to the land. So this notion that there's a change, and I feel, and with respect to Phil and Jeffrey, we will always disagree on this. There has been no change. There has been an absolute codification, which is what's being cried out for, but there's been no change from my perspective, first. Secondly, 7 years, nationally consistent. It's contained within the model participation rules, and it was a figure picked out from the national working group that said 7 years seems to be a reasonable figure, and it accords with existing legislation that talks about the retention of evidence. Duplication of costs. The pre-population of the workspace is completely different to you undertaking a title search of the register book to satisfy yourself in regards to the instruments that are registered and the information that's disclosed. The pre-population of PEXA deals with name on title and registered interests. What it won't disclose are things like easements, pertinent RGs notes that you may need to consider when you're evaluating the transaction and things like that. So for me, there is no limited duplication. The pre-population of information into PEXA is subsumed into the PEXA cost. It's not an additional cost from my perspective, but they are two very different things. One's just the push of basic data. The other thing is searching the register book, which is a lot more powerful and needs to be undertaken to be prepared for that transaction.
Thank you, Brendan. Perhaps, Amy, you wish to comment. So there's a cost to use PEXA, but by doing that, there's some things you may not need to do.
Yeah, look, I don't know that I can add a whole lot to that, but you're not getting a title search, as Brendan said, when you're opening up a PEXA workspace. You're only paying one fee at the end when you settle, which is at $106.26. And in that fee, you've got the verification service between PEXA and the land registry to check that the documents are all in order. You've got the stamp duty verification service between us and RevNet to make sure that the stamp duty's been accounted for. The title activity checks, which are not a title search again, but they're just a check for activity on the title leading up to settlement, so that you may have some additional measure of comfort there. And then obviously your financial settlement and everything moving through that workspace is there. So that's what the PEXA fee is for. It doesn't replace your title searches. You know, it might save you some time out of the office attending a settlement. It might save you time on the phone booking settlements with banks, things like that. But that's part of your settlement and your lodgement and costs that you'd be incurring there. And it doesn't replace any lodgement fees either, which you're still paying, obviously.
Okay, there was a couple of questions at the front, but before we get to that, Tom, I've got a question for you about RevNet. You did mention about timing when to do the batching and what you'd need to do if a transaction you thought would be electronic goes paper and vice versa.
Yep.
You know, just to make some comment on that, and what are you seeing as best practice with respect to sequencing of that?
Well, I think best practice is to make sure it'll be an e-conveyancing transaction before you go into RevNet and create an e-conveyancing batch. If it's not, if you make a mistake and if it falls out, that's catered for in the current RevNet functionality. So you would just delete or void the transaction and put it in a different batch.
Excellent. Just down the front.
It appears to me that the limitation of actions period is going to potentially be much, much longer than 7 years if a conveyancer is negligent and that negligence is not discovered until the next transaction, which could be 35 years down the track. Then I understand, of course, that the cause of action of negligence is not crystallised until the discovery. Given that our top-up insurance is claims made basis, we theoretically have to keep topping up our insurance forever. Any thoughts on that?
Perhaps, Philip, I might start with you.
I'm not sure that that's all that different to now, though, in the sense that we probably still have that potential liability hanging over us forever anyway, almost. But as for the 7 years, I agree that there will be claims that could arise after the 7-year period. Certainly claims on mortgages, for example, that may actually go for more than 7 years. But I think the legislation does actually require you to retain the mortgage for the life of the mortgage, plus 7 years. So if it's a mortgage, then there will be a longer period anyway to retain the documents. With transfers, if they're separate from a mortgage, then I suspect there may be a problem if the documents have all been destroyed and a claim arises.
Yeah, that evidence won't be available.
There's also a compounding problem, because under the Privacy Act, people who retain sensitive information are required to destroy it after a certain period of time. So we've got this tension, I think, between different requirements. And I can't profess to resolve that one.
Okay, got a question in regard to the PEXA, with the processing of PEXA and the financial statement. Is that only visible to the person, like you've got vendor and purchasers representative, is that only visible to you or to both parties?
No, so imagine you've got 4 parties in the workspace, so banks as well. All parties can see the totals and the categories and the amounts. So all parties could see purchasers' equity, $100,000, loan proceeds, $400,000, and so on. What you'd only be able to see would be things like your client's BSB and account details, and things like that. So categories visible to all. Amount is visible to all. Everybody can see the totals because they have to balance for you to be able to get to that ready status. And where there are shared line items, so for example, a payment for council rates, then both practitioners will have visibility of all of the details of those line items.
Obviously things like conveyancing fees and that would remain confidential to you, that wouldn't be seen by the other side?
If it said conveyancing fees, everybody would see the category conveyancing fees plus, the amount there. There is an other category, so I suppose you could have other, but the amount might give it away depending on what that is. And that's both sides can see everything that comes through. There's also an option to have all proceeds apart from the loan payout, stamp duty, lodgement fees and so on, but all of your client proceeds paid back into your trust account if you then want to deal with them outside of PEXA. And obviously there's always the option to bill your client outside if you don't want to get those fees out as a line item, but probably prefer to get paid.
Obviously other conveyancers don't see financial settlement statements now, they only see an adjustment statement. So
yeah, so it's increased transparency and visibility, you're right. So that would be a shift.
Okay, I've got another question, sorry. In regard to manual electronic lodgements at the LTO, is that we've always been led to believe that will always be available, that manual lodgements will always be available as well as electronic? And with the sale of the LTO and privatisation, is that going to change anything?
Brendan, for you?
No, not at this stage. There's no other jurisdiction. Well, a couple of other jurisdictions have mandated mortgages and discharges. At this stage, there's no proposal to mandate anything through PEXA, and so therefore the paper lodgement channel will exist.
Will that change if it gets privatised and the LTO is sold?
That's not. I have no visibility of any of that.
That mandating, of course, is for a standalone mortgage or discharge rather than part of a larger transaction.
And it's only for those that are lodged by ADIs, so it's a limited class of lodgers as well at this stage.
Up down the front.
Can a registered power of attorney still be used when transferring land, and if so, how would it work with the client authorisation?
Yes, and again, it goes to the authority of the person to act. So if your client is purporting to act on someone else's behalf under power of attorney, you need to satisfy yourself that they have actually got the power under the power of attorney, and then they can grant the client authorisation. We've always talked about the grantor around VOI. If there's a power of attorney, you identify the grantee, but the grantor has always been a bit of a loophole for people that have looked into this space for a long time. There's a review currently going on under the Power of Attorney and Agencies Act, and I've written to the attorney to see if we can invoke VOI upon the granting of a power of attorney, so we can capture both sides to close, if you like, that small loop that exists.
And of course, the power of attorney would need to be registered.
Yeah, still needs to be registered.
And you'll need to retain a copy on your file for 7 years. That's part of the supporting evidence of the verification of identity and therefore the certification.
Does anyone else have any further questions? First, sorry, gentleman at the front, and there was somebody at the back. Josh, yeah, cheers. No, you go first.
Hey, you're
yep.
That's the checks that still will be done in famous and no cost. Is that right?
Yep.
Let's go.
With the dispersal of funds from your trust account as a conveyancer to the land agent, is there or should there be a place in the workspace for verification of identification or authorization on the land agent? Because ultimately they're the ones that give you, the conveyancers, the work.
Sorry, are you saying, and excuse me if I got this wrong, are you saying the obligation to do the VOI and the VOA, if I use those acronyms, should be pushed out to the land agent and not necessarily with the practitioner, or should it be done by both?
No, the question was does the conveyancer need to perform one on the agent giving them the work?
No.
Because ultimately the conveyancer is dispersing the vendor's funds to the agent's trust account.
So in PEXA, if you're dispersing funds on behalf of your client, then you should be doing that on your client's instructions. And if the client is instructing you to, pay a party, then they'll be giving you all of the details. If it's common practice that you're making a payment to the agent for whatever reason, then you should definitely be making sure you've got the right account details, BSB account and so on. But there's no requirement under our system to VOI recipients of funds. They're all fully traceable. It's an electronic system, and we know we can trace where they've gone. But there's no separate obligation to go and check the ID of everybody who's receiving funds out of the system.
I just thought to cover your backside in the dispersal of funds to agents, it would be a good practice.
It might be a prudent practice, but the legislation only requires verification of identity authority of the parties or people who are signing on behalf of the party. So everybody who signs the client authorisation must have their identity verified and their authority verified, but it's not necessary to drill down to the agent. And you may choose to do so, but I would just get instructions from your client to pay the agent, and it is not necessary to verify their identity unless your instructions require it. No change there.
Yes,
Yes.
With the emphasis towards us in that we conveyancers have a big responsibility regarding educating the public, will the government be running a program to educate the public?
There are conversations happening as we speak around the campaign that we can run. It's a point in time campaign. People only transact every 7 to 10 years, so the message gets out there today, and if you're not in the market right now, the message is sort of lost. So there's an upfront campaign or awareness, and then the trick is how we repeat it or how we get enough information to the practitioners within the market to arm them so they can have those conversations at the point in time when someone's entering the place. We tried to do it with VOI. We released a media release, and I'm not sure it got picked up by any major outlet.
It would have to be something more substantial than being just noticed in the public notices on the page 37 of the advertisement.
We will try.
I think this provides an opportunity for practitioners to communicate with former clients to inform them about the changes, and particularly if the client might be holding a duplicate certificate of title as security for a loan, because obviously once the duplicate certificate of title ceases to be a valid document, that security then disappears. The loan still stands, but the security of the duplicate CT will have gone. So I think it behoves us all to communicate with our clients to inform them of the changes proactively, apart from when they first contact you to say that they're selling or buying or otherwise dealing with their land.
Gentleman down the back.
Just a quick thing to splash through the mind then was the fact of we get probates, no further grants of probates under the thing. So I gather there'll be places for us to maybe insert that or locate that as further information.
So not currently. So at the minute, it's not in scope. I suppose we're always looking to expand the scope of transactions that we can cater for, but they're not in right now.
Yeah, because we're required to state whether there's further grant of probate if the leave's been reserved, which then led on to the mortgagee sales situation where we get a 55A Law of Property Act, or secondly, currently when you do a mortgagee sale, you're saying that you're also transferring the interest of the registered proprietor who's not a party to the transaction, but the bank as mortgagee takes on that role. Now, I'm just wondering if that's been fine-tuned or whether that's something that's got to be looked into.
Perhaps, Amy, you wish to just go through the general scope for
Yeah,
PEXA for the
okay,
first wave of
mortgagee sales are not in scope for PEXA at for the time being. So what we can cater for in terms of instruments are transfers, discharges, mortgages, caveats, and withdrawal of caveats. And when you're talking about transfers, if you think your stock standard vanilla transactions, so no additional instruments or documents that need to be lodged with them. They need to obviously be capable of being assessed in RevNet so that we can run that service between us and RevNet. The transferor needs to also be the proprietor on the title. What else? Look, there are some other restrictions. Banks for the time being are not putting through the commercial type transactions. So it's your residential sales and purchases that you're likely to find will be suitable for PEXA for now. And obviously, as the network expands and volume picks up, then we will be seeking to constantly expand that scope. But that's what we're looking at for now. Sorry, and priority notices in time.
Thank you, Amy. Down the front, Josh, you've got a fair task to swan down here, but do your best. Watch your head.
I have a simple question. The conveyancer and the bank mortgagee disagree as to correct VOI and VOA. And the bank asks the conveyancer to change his verification of ID, VOI, and verification of authority. Who should be correct or not? In my book, I said to the bank, no, I certify for the whole of the land, which might be $1 million, and you only certify for your mortgage, which only be 40 or 50%.
So,
who will be correct?
Well, I suppose that's
both.
How can it be both?
Because the requirements stipulate that there's a standard that says if you follow that standard, you are deemed to move to safe harbour and I will assume the risk. But they also say that you can take reasonable steps. Now, the bank and yourself may decide to have what you constitute as reasonable steps may be slightly different. And that's where it becomes difficult around VOI, because what I say is reasonable in a set of circumstances, Tom might say, no, that's unreasonable, but we both could be correct until the matter may go before the courts. And then someone will make a judgment.
I can tell you that I am correct.
Okay.
Because I'm taking more steps than the bank officer took it. And I know that's a fact.
Thank you. I'll take that one on.
Well, this is an old chestnut, isn't it, Angela? So, but the transfer, in my view, is got to be the key document. So, if it's the incoming mortgagee, then you will have done the verification of identity, and so the name on the transfer should be the same name as on their incoming mortgage. And if the incoming mortgage is in a different name, then they need to change their mortgage, or there needs to be a change of name done after it's transferred from the vendor to the purchaser. That's I think your issue.
And the real thing what happened, the bank takes the passport and the driver's license, but the driver's license, the names, the second and first name are switched around, which I take those and also take the certificate of Australian citizenship certificate, and I match them together, and the bank is wrong.
in PEXA, your documents, you'll set up your client's details, and then all the bank's documents are created using the name that you put in there. So you'll win in our system, but you might have to have a discussion with them, about the difference.
You have to engage.
Can I invite any more questions from the floor? Yep, gentleman in the blue, and then we'll move to the gent in the purple.
This may be an easy question to answer. In regard to talk about transfers, the tradition is now that banks require a copy of the transfer in the initial process when they're processing the loan docs to see what's going to go through. But with PEXA, of course, there won't be any actual document as such. So will they actually just go by information that's in the workspace?
They should do, yeah. So they should have visibility of, as I said, the purchaser's details, proprietor's details are coming back from the registry anyway. So that's visible consideration, things like that. So they should just be relying on what's in there. I can't really speak for what all banks are doing in terms of how they're processing their loan applications though, but I would expect, short answer is...
There'll be no actual physical document to give them, so...
Yeah, that's right.
Yeah, I mean, and to extrapolate Josh's demonstration before, the data which was populated in the workspace is shared among all. So it will be so they, for instance, if it's an incoming mortgagee and the purchaser's representative, they're not building the workspace in isolation, they're using that same information. So, and there's an option to then converse in the conversation tool if you believe that there's differing information.
I haven't done this before. Where actually is the form of the transfer? The purchaser conveyancer signs it instead of the ordinary person, and the other one conveyancer signs for the seller's conveyancer. Where's the actual form? You're still downloaded from the LTO forms, or is it actually in PEXA so that the bank sees it too? Because now the bank rings up, he wants to, have you done the transfer? Even though nobody signed, he wants to send them across to them, fax it across to them, or email it across to them, so they do their mortgage documents. Not that they can't do it, I think, so they get exactly the same spelling, same right.
Yeah.
So how does that?
Well, in paper, it's simple. You just get it from forms online, LTO forms online.
Yeah.
So the format will be there with the certifications printed on the form. So you'll be able to print that out and sign it, etc.
I sign it. How does the other say?
They sign it.
How does the other seller's conveyancer sign it?
It goes to the seller's conveyancer, if that's the conveyancer on the other side, and they will physically sign it.
I'll post this just
as
I'll do now.
Yes, exactly. And electronically, it's all going to be in the workspace, so you will digitally sign on behalf of your client, and the conveyancer on the other side will also digitally sign on behalf of their client. So that's how it happens electronically.
I don't actually post it across anymore.
No. There's no piece of paper that's sent between the conveyancers. It's all on your workspace.
Yeah, that's part of it. So the form is in PEXA now.
That's right. Well, for electronic, the form is in PEXA. For paper, it's in paper. It's a paper document.
In electronic, if you remember from Josh's demonstration before, there was the menu you moved down the left-hand side, and one of them was documents. So really you're clicking a button that says create transfer, and then once you've created the transfer, yep, and then you can sign it. That's it. Yeah, it's not really a form. That's right. And they can see that you've created a transfer. You've signed a transfer. All the parties have done what they need to do, or one party still hasn't done something. That's all sort of there, and the information's available to everybody.
So the buyer's conveyancer signs it in PEXA.
Yep.
The seller's conveyancer signs it in PEXA. The bank has a look at it in PEXA. It's all in PEXA. We don't need to print anything.
Don't need to print anything or do any of that. That's right.
Right.
Just following on from that question, and nobody's asked the question yet, but it's important to note that unless everybody wants to play in the PEXA space and everybody's able to play in the PEXA space, the transaction settles in paper. So it could be that some, but not all of the parties are maybe subscribers to PEXA, and if that's the case, for example, then it will have to settle in paper. It may be that but for whatever reason, a subscriber does not want to settle in paper, or it may be that the transaction can't settle in paper. For example, if there's a document that has to be lodged in series, that can only be lodged in paper. So let's say, for example, that there's an application to register death that can't be lodged through PEXA. So that has to be lodged in paper. Now, it may be that that can be lodged separately in paper and the rest of the transaction can happen electronically, but it may be for whatever reason that the whole thing then needs to happen in paper. And I think we'll find that in 1 year's time, might only be 20% of transactions will actually be settling through PEXA. The rest will still, I think, be happening through paper. But that percentage is going to rise, I think, quite dramatically, because I think people will find that it will be quite advantageous for them to settle, and for their clients too, for them to settle through PEXA.
Lady down the front in red.
Sorry, this is a PEXA question. Now, in relation to family law matters, like you said, everything is transparent, everybody can see, the wife might not want to see the husband that she's borrowing so much to pay him out, etc. So have you thought of maybe developing a tool that, right now that information is private, isn't it? How much someone is borrowing, but now it's everybody can see everything. So
yeah, so if you're settling through PEXA and there's a transfer through PEXA and there's, usually you'd think there'd be some orders in place in relation to the amount that needs to be paid, but then the source of funds will either be from a bank if there's going to be a mortgage or from the trust account. What we're finding is that a lot of banks will take an authority to then advance the additional funds from a customer account. So you might have the bank providing all proceeds, even though part of that's, going to support the loan and part of it's just coming out of the customer account. Obviously, you as the practitioner can have your registered trust account or otherwise to put funds in where that's required. But ultimately, the short answer is everybody's going to have visibility of those category amounts and where the funds are coming from.
It may be the answer is that the money goes into your trust account and then it's dispersed from there if it's a question of identifying where the money is going rather than going directly to a party.
Yes.
I have a question surrounding risk and verification of identity and reasonable steps. With the advent of electronic conveyancing and the need to keep documentation for a long period of time, do you think it is now necessary for us to obtain and keep documentation to verify the identity of people who are well known to us, for example, family members?
Is that question for me? What I would say is it says you must take reasonable steps. So you need to keep evidence which will prove that you took reasonable steps to validate someone's identity. Now, if it's your mother or your sister, I only have my own personal view. I'd hate to step in the shoes of a court, but, I think, it'd be a pretty long stretch to say that you kept some photographic evidence of your mother, for instance. We've got to be practical. That's why it's hard when you have conversations around what is and isn't reasonable steps. Everyone has their own limits on what risks they're prepared to take around VOI and even VOA to some extent. How far do I need to go in this set of circumstances? Very subjective. I'm sure all five of us up here would probably have a different view and appetite to risk associated with any level of identification, so it's difficult.
Thank you, Brendan. I think your mother would be happy that you're keeping photographic evidence of her. There was within that question, Brendan, there was another question about the retention of documentation. That applies to both channels, or as in yes. Paper or electronic, or
no. That because we've aligned, it's both channels. As Jeffrey rightly pointed out and emphasised, doesn't matter whether you lodge in paper or electronic. These reforms affect you. Everything is consistent. Where you lodge it, that's a choice of yours. But what isn't is VOI, VOA, client authorisation, dupe titles, flows through everything you do.
Gentleman front.
I, for one, will be getting, when I'm using electronic, I will be getting my clients to sign an old style transfer for their own gratification to know that I am doing my job. Just a comment.
Thanks. Down the back.
Is it correct that in terms of retention of documentation, you're comfortable that documentation can be retained electronically, so you don't have to actually have a physical copy of a passport and a physical copy of a driver's license?
I am. Sounds like I'm getting married. Yeah, I am. But the Act is silent. The Act doesn't prescribe how you choose to retain. And I think I've been on the record before that says, look, in this day and age, I think we have to allow people to store things electronically.
Yes. I'm a little bit confused. I might be misunderstanding something, but I thought after 4 months transition, all conveyancers have to use electronic. Is that right? No.
No. No, no. 4 months is dealing with the way the Act operates today against the new provisions. It doesn't impact. We need the new Act to be able to lodge through PEXA. So if you're doing it the old way, you probably won't be able to lodge through PEXA. But if you do the new way, you will lodge through PEXA. But the paper channel and the electronic channel through PEXA will both coexist once a bill becomes the Act.
Yeah, just a comment, I guess, to start with. Given that we're moving, into an electronic space, I just find that, and it is a big change, as you've said, in the last 150 years, I find it odd that the default is going to be going back to the old style, as in paper transactions. So, I understand that not all the transactions at this point can be done electronically, but if that's the way we're pushing, and that's the way we want to move the industry, to be having the default where one of the 4 parties, say in a normal transaction, discharge, transfer, and mortgage, one of those 4 parties says, I want to go down the paper route, everyone has to abide by that. So I just find that a little bit odd. I guess my question really is, are we able to complete an entire transaction electronically, so paperless? So, we get the contract and the details and the searches are all electronic. The client authorization, can that be signed digitally and retained? I can't see any reason why I couldn't, but I'll just ask you guys.
The Electronic Transactions Act carves out property transactions. It's an exemption to the ETA currently. Work and conversations are still taking place whilst we need to make some changes to those regulations to facilitate electronic conveyancing. You mentioned contracts for sale and broader land-related instruments, let's say. They are still captured by those exemptions as it currently stands today. So there is advice floating around that may challenge some of that thinking. However, as it stands today, contracts for sale must still be wet signed, subject to people getting their contrary advice.
Yes. Yeah, you go. Yep.
For a buyer, you've got this passport and you've got a driver's license that makes verification of identity. But verification of authority, you mean that though the same name is on, you've only got the contract, his name on the contract? Is that what you mean? This passport there, so what's on the contract, or is I don't quite see. The authority is only a buyer, you only got his contract.
You need to, the buyer.
So Brendan, I just might repeat the question just for the guys at the back. Verification of identity is a collection and viewing of documents. In addition to viewing the contract, what are the steps in which one could complete a verification of authority?
Yeah,
for the buyer.
For the buyer is probably not that big of an issue. It's the seller where the real issue comes, where you've got to do the verification of identity, and just because they're disclosed in the contract, I wouldn't assume that they necessarily own the parcel of land for which they've entered into a contract on. So you need to attach them back to the property through the guide, and the guide, well, not just that, because that will just disclose the name. You need to go and have a look to say, okay, Brenton Pike is Brenton Pike. I've ticked that. I've got VOI that says I am, but am I the Brenton Pike that owns the property in Greenwith? What do you need to get? What do you need to satisfy yourself that I am Brenton? Well, your VOI is done, but I am the Brenton Pike who owns the property at Greenwith. You need to go on, have a look at the right to deal guidance notes on the ARNIC website, and there'll also be verification of authority guidance notes that will give you strong guide on how to go through that process.
Jeffrey, I know you've investigated this quite length. What's some of the tips you have for verification of authority?
Damn. Well, it depends on the circumstances. Obviously, you've got to take reasonable steps in the circumstances, and part of that depends on who is the party. So if the party you're acting for is, say, the transferor, then you're going to do a title search, obviously, to verify that the name of the registered proprietor. If it's a company, then you're going to be drilling down to do a search with ASIC to identify who are the directors and secretaries, so that those people are going to be signing, so that confirms who those people are. If there's a power of attorney, it's searching with the Register of Deeds, so you get a copy of the registered power of attorney. If it's not registered, then you need to get the power of attorney, which will need to be registered with the Registrar General. There could be other things. It could be a disclosure statement, obviously the contract. It could be the guidance notes through ARNEC talk about getting a copy of a utilities account, a rates notice, land tax assessment, etc., that ties the person, as a transferor, the person to the land, because that's the link that you're looking for, tying the person to the land, right? And if they're acting in the capacity of, say, a director of a company or an attorney under a power of attorney, then you're looking for those documents as well to establish the capacity to represent the registered proprietor. If it's something like a transferee, then you're going to be looking again at the contract, the disclosure statement, because the disclosure statement will be going to the purchaser. There could be mortgage documentation as well, from the bank, etc. On the purchase side, the documents tend to be a bit scant, not so much on the vendor side. And there are other parties too, caterers, encumbrances, etc. So if you look at the guidance notes, there's a list of documents that you should be sort of in scope to ask for. You really need to look at the guidance notes from ARNEC, all the guidance notes, because they are very informative, because they apply also to paper transactions, given that there's the alignment between the electronic process and the electronic transactions and the paper transactions. So you need to go to those guidance notes and read them carefully, and they're very informative. Have I answered your question?
And I just mentioned a couple of grey areas that I'm not sure that are fully covered in the guidance notes, but perhaps other members of the panel might be able to help to resolve them. And one of those is if the purchaser or the vendor is a company, how far do you need to go? Do you need to see a resolution of the directors of the company authorising the purchase or the sale? Or can you just accept the fact that that is a director of the company and you've verified their identity? So there's that area. Also, if the purchaser or the vendor is a trustee, do you need to review the trust deed and see if they have power to purchase or sell? And it may be regarded as common proper practice, but whether it's part of taking reasonable steps is a slightly grey area, I guess.
And I would say the answer is yes, you do need to do it.
I would say so, yes.
Thank you, guys. Yep.
I haven't done it yet. Is the power of attorney, can that be done through Savers from home? No, not yet.
So,
go to the office.
question was, could a power of attorney be done through Salus? And the answer was no.
Oh yeah, you can order a
You can
copy
do
of it.
a search.
Sorry.
Yep.
If a power of attorney has been lodged and you are searching the power of attorney index, you can do that remotely. Yes, and order a copy, yes, sorry. To lodge it, you must come in, yep.
Cheers.
Just a question regarding the verification of authority. It's been our common practice dealing with a file, especially for the vendor, to get a copy of the previous transfer and compare signatures. Will that still be accepted while they're still available as being part of that process?
I'm not sure who you want to answer the question, but I think it's a really good process to do now. But of course, going forward, it's going to be a conveyancer signing the transfer on behalf of their clients. So that will cease to be useful in those circumstances.
Obviously, you can still compare the previous transfer to the authority that you get signed to see if the signatures are still the same as, well, in the interim while they're still available, of course,
Yes.
until obviously they're not available anymore.
Well, it's certainly a step that you can take that should convince you that the person does have the authority, or they are who they purport to be.
Just to return to the proprietor as trustee, now to satisfy the ATO, we give the accountants a copy of the transfer that says the consideration was paid for and on behalf of the trust. What sort of documentation will the LTO have of a transaction that's been done through e-conveyancing? Is there any paper trail or anything like that?
I'm not sure if that's a consideration that can be utilised within the PEXA system, and if it's not, you'd still have to lodge those type of transfers. If you want disclosure in the physical transfer document, it'll still need to be lodged in paper. However, I will defer to see whether that consideration or that certain disclosure within the consideration panel is available in PEXA, because I'm not certain about that.
You can view a rendered image of what the transfer is going to be, and you can do a search in the other states. You know, you can search the instrument later and a rendered image will be produced. So that might help you. And what we also have, I suppose, if you're just trying to prove that some consideration has passed, is that you can print what's called a settlement completion record, which shows everything that's come in and everything that's gone out financially. So what's visible to you in terms of categories and amounts. And that can probably help you with other sorts of reporting also. If you're putting money in from trust, you get your trust account authorization record and then that settlement completion record to put on your file.
And how long after the settlement's been completed will that be recoverable?
So any data that's in PEXA will retain indefinitely. There's workspaces you can, I think, access fairly readily for
18 months.
18 months, and then you'd have to approach us, I suppose, if it wasn't there for you to pick up on yourself by yourself. But it will be still with us, and we're not getting rid of any data from the workspace.
So I suppose an important distinction is there's the model participation rules, which you will all be subject to as an electronic lodgement network operator. PEXA is subject to the model operating requirements, which mean that any data recorded in the exchange is to be kept indefinitely. That also includes for files that don't go through to completion as well. So those who are interested in data retention and information retention, anything you've completed in PEXA will be able to be recalled indefinitely. We're still seeking a ruling on how long indefinitely is from the chairman of ARNIC.
Who's that?
RevNet will carry copies or carry the evidence that was brought on behalf of the trust. How long is RevNet activity accessible?
As it is now, it's not going to change. Yeah. So anything you're putting into RevNet now will continue to remain in RevNet, regardless of any PEXA process.
I'll beat him. I've got the microphone. Brenton, listening to everyone talk and that sort of thing, one of our main focuses for VOI is to have a photographic record, and obviously passports and driver's license at the top of the list. One of our main backbone, I don't think there's anyone in the industry hasn't encountered driver's licenses. It's an absolute disgrace how they record it. Now, we have to keep our records up to fairly good standard, and it seems to me you can go to Department of Transport and get the licenses. They've got the middle initials missing. They might go for an anglicised version of the person's true name, and therefore we use a bit of discretion. I understand that, but surely going forward, the pressure should be on the government to say, if this is going to be a reliable record for identification, we should be pulling our act together. So I'm just wondering, does that get raised with the government? Thank you.
I think the ironic part, Tony, is if you ever looked on the back of the driver's licence, there's a disclaimer that says it's not to be used for identification purposes.
We've got 10 minutes to go. I was wondering, got the.
Got a little bit confused there.
So if you could start speak a bit closer to the mic, just
I
for
got
the
a little bit confused there. If after the 4 months the person did the old transfer, say you got it on paper there, you do it exactly like the buyer and the seller would have to sign it, then or the conveyancer gets the authority, and just the conveyancer buyer signs it, and just the conveyancer seller signs it, but the actual seller won't sign it, and he won't be verified, and there will still be at the back there that somebody has to certify that's all correct for the Property Act and all the rest.
In the new world, the rules will be that the representative of the buyer will sign the transfer. We're talking about paper.
Yeah, paper.
You will sign it on behalf of your client, the seller. You will verify your client's identity. Yeah. You will get the authority to sign the transfer. You'll retain the evidence for 7 years, and you'll give me a certificate to say this is all okay. I will, acting for the purchaser, sign it as the practitioner for the purchaser, and I'll give a certificate saying I've verified my client, I have an authorization, I retain it, and it's correct.
And we'll still go to the...
And in paper, you still go to the settlements room.
Settlements room. So the only difference is that the conveyancer signs it in the panel there, and the other conveyancer signs in the panel, but the original seller, the original buyer doesn't sign anymore. You don't need any witnesses.
No.
Correct.
All right, Josh, maybe we'll call for one more if the panelists are right to hang around to answer any direct questions at the conclusion. We're just starting to lose a few attendees, so I think people are looking to make a move.
Jeffrey, this one's for you. Just one last thing, and yes. Maybe the PEXA representatives here as well. Are you planning to go into places like Queensland where we're not registered? And if you do, are we able to transact there?
Maybe Amy, if you wish to talk about the PEXA subscription with respect to that, and then Brenton with application of the ECNL.
We're talking about conveyancers, not lawyers.
Yep. So there's no change. If you're not able to transact in Queensland in paper, then you can't do it in PEXA, and our system won't allow a conveyancer to transact in Queensland. If you wanted to transact in other jurisdictions and you're based in South Australia, then at the point of registration, we'd be looking for your mutual recognition certificates from those other states before we activate you in those states. But that doesn't apply for Queensland.
Thank you.
Alrighty, well, let's draw it to a close. Thank you for your attendance and attention today, and your cooperation in passing around the microphone. If I could just ask you to say thanks to the Law Society and also the panellists today, Philip Page, Jeffrey Adam, Amy Garrity, Josh Radford, Tom Coleman, and Brenton Pike. Cheers.
Brenton, press the button. Yes? No, press the button on the change.
Yes. Yep. Oh, what's up there? Oh, good luck.
Questions?
Good luck. It's not working. Come on. That's bad. Yeah. I've switched off. That's why. Good luck. There it is. Good luck.
Well done, Matt.
Yeah.
Yeah. Okay. Good. So they're in scope.
Yeah, look, I was going to go to.
Aggregated section 67.
There's some rules I think
Brenton said
we've got about 96% about
He's got that, but look,
trying to get my head around that threshold.
I'm quite confident that they will use it at some stage.
Okay, thanks.
I can't believe that they will.
Tomorrow.
Let's stand up. I'm glad I swapped the seats.
Sorry.
Yeah, oh, look, that was so good. I'm happy to have it. Sorry, wasn't